Okay, so the first item on the agenda for the public hearing is the presentation on the determination of capacity for Landmark LLC and Jarvis LLC concerning a development on Calkins Road. So, is there anyone that would like to address the commission? And if you just identify yourself for the record.
Sure.
Please.
Glenn Russo, 288 Marguerite Road, Middletown, Connecticut.
Thank you.
I am the executive manager of Landmark Development. And so I'm going to pick up from where we left off at the last presentation. I just want to make 5 quick points to recap at the last meeting. So there's a lot of history that we went over the last time. I think that we showed that East Lyme's sewer crisis narrative is unfounded. East Lyme officials have made false and misleading statements during public hearings. The East Lyme Sewer Commission abused its discretion on numerous occasions. On the false statements, that was backed up by the letter by the DEEP regarding the false statements on the sewer shed. The abuse of discretion was backed up by the judge's memorandum. East Lyme derived a strategy of blocking affordable housing applications through unlawful weaponization of the sewer allocation. That strategy started back in 1999. That was documented by the minutes from your attorney, who basically said the way to stop affordable housing is not through the zoning, but through, because you'd lose, because it's the 830G statute, but rather attack it through the sewer allocation. And again, that was substantiated by notes from a meeting, several meetings between the staff and the attorney Fuller. And the regulations themselves are unlawful, particularly the 12-month filing deadline and the 48-month completion deadline, which I will get into in more detail tonight. So moving forward to the sewer capacity analysis. So Landmark put together an analysis not based on engineering theory or modeling, but simply based on the city's own numbers. And for the sake of the argument and for tonight, we've adopted all of this city's numbers. I may have said state, I meant city. We adopted all of the towns, sorry. We adopted all the towns' numbers. Even though we don't agree with them, again, for the sake of argument, we adopted them. And so what you have here is a chart that goes back to 2012, which would be a 13-and-a-half-year time frame. 2019, 6.5 years, 2021, 4.5 years, and 2023, 2.5 years. And it shows that in the 13.5-year period from 2012 to 25, the town had an annual increase of just 2,000 gallons a year. And if you take the 6.5 time span, it was 3,138 gallons per year additional capacity was requested. Those are extremely small amounts. If you go to the 4.5 year, it's actually the capacity as the town had actually increased by 12,555 gallons per year over a 4.5 year period. And if you look at the last 2.5 years, the town has gained in capacity 50,015 gallons per year. So when you take the town's available capacity of 119, which is the town's number, not ours, and you subtract the amount that you have available, or the amount that we're requesting, and I should say that we are modifying our application from 125,000 gallons to 95,000 gallons. So if you take the 95,000 gallons and you subtract it from the 119, at least 24,000 gallons, and if you apply the trend, past trend of 13 and a half years, that would give the city around a decade of capacity after we would get our allocation. If you use the 6.5 year trend, it'd be 7.6 years, and of course, if you use the 2020, the 4.5 year or the 2.5 year trend, the amount that the town has been saving over that time period would be greater than the amount that we are requesting. And so I'm going to go to figure 1. So here is the town's sewer over the past 13 and a half years. And so the green line is the total sewer, and the dotted green line is your trend. So the overall sewer capacity total has declined. And the blue line is the East Lyme's, and so East Lyme's has increased slightly. And the state of Connecticut, which is the red line, has decreased over that time period. And again, the solid lines are the actuals, and the dotted lines are the trend lines. And the trend lines just even out the highs and the lows. And so you can see there was a slight increase in the town's usage, which is the blue line. So then you move to, and 13 and a half years is a pretty long time frame, and so you can shorten up to 6.5 years. And once again, the green line is the total. It shows pretty unchanged, 904,000 gallons versus 903. The states basically went down to about 182 and has been pretty level since 2020. And the town would be the blue, which is a slight increase, 687 to 708. So then you get into the 4.5 year trend, and you see that the total sewer capacity has gone down. East Lyme sewer capacity has gone down, but the state has been virtually even, 189 4.5 years ago, 195 today. That's so you can see that the trend line is almost flat. And so what Ben had said last week was true, in that in the long-term trend on figures 1 and 2, the overall was going down, the city was going up, and the reason for the overall going down was because the state's allocation was the lowest. They're actually, according to the minutes, is one of your largest, if not your largest, user of sewer, your largest payer of sewer, and obviously when they reconfigured the population at the prison, it dramatically dropped the amount of sewer that they were using. And so that lowered the overall. And then you get into the 2.5 year, and because 2.5 years is a shorter time frame, you have to really switch from the prior diagrams to a bar diagram. And so you have, once again, green is total, red is the state in the last 2 years, 2.5 years, 193 to 190, 193.3 to 195. So again, the state is very consistent, very steady. They're right around that 190 mark, 180 mark. And the town has reduced their sewer capacity. The overall capacity has gone down, and the town's capacity has also gone down from 757, I'm rounding off, to 708. So the town sewer capacity has actually gotten better over the last number of years due to primarily a very small amount of users and other things such as the economies of water appliances. For example, prior to 1970 or so, a toilet used 7 gallons of water. Now it uses 1.3 gallons, I think. So as people remodel their homes and they replace the inefficient toilets and sinks, not sinks, well, even the sinks and the faucets have water savings. You have your dishwashers and your washing machines that use substantially less. So that contributes. The town, as we read through some of the minutes, they have better metering. So it could be partly attributed to the town simply measuring better, and so more accurately. There's also issues with individuals illegally dumping groundwater from their sump pumps into the sewer system, and the town has sent out flyers and done some type of outreach, and that also could be having an effect. So when you add them all together, the town is actually gaining capacity through the items I just mentioned to you. It's hard to determine exactly how much is in each category, but clearly the trend is that the town's capacity is growing. And it's over the 4.5-year trend, which is more than sufficient to eliminate any anomalies due to weather and whatnot. So clearly, the town is gaining capacity over the last 4.5 years. And so the next group, and I'm just going to kind of slide through this, but I wanted to show that these are all the town's numbers. These are all from your sewer flow reports from the states going back many, many years. So we took all of that data and we put it in to those graphs. So again, this is simply taking the town's own information and representing it in a graph form. There is no projections or theories from engineering that you have to buy into. This is simply using your numbers, your trends, what you've used, what you have, and it clearly shows that you have sufficient capacity to grant our application. So then I want to talk to the regulation itself. We believe it's illegal, and we believe it's illegal for a number of reasons. The first letter that I would like to go over is from Mary Beth Marr, I believe it, Matta. She's the Chief Executive Officer, and I'm not going to try to pronounce that, Consulting Group, ALODGIO. And she basically says that they've been doing this for a long time, 30 years. They're experts in the field, that they're writing this as a professional opinion regarding the critical financial barrier introduced by the sewer regulation adopted by East Lyme. Specifically, they mention section 2-4 of the regulations, and they talk about the 48-month completion requirement. This, and she goes on to say, this is not merely a preference or an inconvenience, it is a structural impediment to funding. And so her conclusions are, and I'm trying to just hit the high points. It says, in our professional capacity as a multifamily financing specialist, the 48-month sewer capacity allocation limit makes the 864-unit project financially unfeasible. Projects of this size inherently exceed the 4-year completion window. No financial institution would provide funding under the current regulations. It's not a financeable project because you guys can pull the funding if the project's not finished in 48 months. No bank is going to underwrite it. with interest rates and all the other different variables, lease up and whatnot, is simply not doable. And I would point to the state of Connecticut, which gives 10 years for a site plan, and I believe 4 or 5 years of an automatic extension, provided you don't change anything on the plan. So 4 years is just completely unreasonable and undoable and unfinanceable. And so the other part of the regulation is the 12 months to file for your applications. Once again, it is impossible to adhere to. And so the next letter is from A.H. Hesketh. They have been in the development, regulatory, engineering business for many, many years, decades. They've actually been involved in this project since 2013, so they know the time frames associated with East Lyme in this project. And they basically say that the 12-month requirement is for the most part unachievable. And they go through and they basically list some of the things that an applicant would have to go through. And they demonstrate that it's impossible to adhere to the schedule. So steps 1 through 3, those are done prior to coming for the allocation. So the clock wouldn't start yet. So you have to secure the property, conduct initial feasibility studies to determine the development potential, wetlands topography, do your layout, and then file with the sewer commission and receive your sewer allocation. So those are the first 3 steps that a developer would go through under these regulations. And then he talks about the redesigned preliminary land plan based on sewer allocation. So of course you'd have to redesign if you didn't get the sewer allocation that you requested. For example, Niantic, something, it's up the road here where the old gas station is. They had a development of a certain amount. They wanted 110,000 gallons. You guys gave them 75. Complete redesign. Basically they were almost starting from scratch, because obviously you can't do anywhere near what you planned at 110,000 gallons of sewer if you're granted 75. So right there, they have here that best case scenario, you can redesign it in a month. Realistically, it would take you a month and a half to come up with just a redesign. Then you have to go on, so you have to do detailed field wetland inventory and environmental impacts, 1 to 2 months. Field locate the wetlands and delineate the land survey, 1 to 1.5 months. Detailed survey or aerial topography, 1 to 1.5 months. And it goes on revising your land plan based on the verified of your topos. You have to go out there, you have your plan, but when you actually do the topography, you realize, geez, this building we can't get to it without major grading, and we have to relocate it. Oh, there's wetlands that we didn't show up on the initial town map, so now we have to stay out of the buffer. So you have all of this back and forth, and so you're revising the plans as you're getting better and better detailed information. And of course, you have your traffic studies that you would have to do. Then you would go in for your inland wetlands and planning and zoning reviews and approvals. You'd have your Connecticut DOT and OSTA permit if you were to have more than 100 units. So any development, I don't know if people on the sewer commission realize it, but if you exceed 100 units, you have to go and get a special permit from the state of Connecticut. It's called an OSTA permit. And that could take anywhere from 6 to 9 months itself. And there's many applications that are beyond a year just getting your OSTA permit. And then you have, once you do that, you have to have your Connecticut deep stormwater permit filings, 1 to 1.5 months. So they're calculating that it's 2 to 3 years to get the approvals. 2 to 3 times the 12 months. To get all your approvals 2 to 3 times. Now, one of the things that Ben said was, well, you don't have to get all your approvals in 12 months. You just need to apply for them in 12 months. The problem with that is that certain permits cannot be filed in a parallel fashion. They have to be filed sequentially. And I will point to a few documents in a moment. So it's not you just apply for everything at the same time. First of all, from a practical standpoint, it makes no sense, and no developer would do that, because you're certainly not going to go for your OSA permit until you get your site plan, because the geometry of your traffic light is all dependent upon the number of trips, which are dependent upon the number of units. So, for example, if the person who came in for the 400 or some odd units and wanted 110,000 gallons, ultimately got either by you guys, by a lot of times the planning department will cut buildings. The wetlands agencies are notorious for cutting buildings because they don't want to be in the buffer and whatnot. So every time a building gets cut from your plan, that affects the number of units, which affects the number of trips. So now your traffic light signaling is all messed up. You have to start over again. All your geometry, so when you design a traffic intersection, you have a stacking lane, right? So you have cars stacked to make a left-hand turn. Well, that stacking lane is based on the number of cars. It's all timed. And so you really can't go in and engineer for your OSA permit until you know how many units you actually are going to walk away with, which is rarely what you apply for. And then once you get your final approval from both wetlands and your site plan, then you could say, okay, we started out at 800, now we're at 600. Well, that, the stacking lane is shorter, this, that, and the other thing. So from a practical standpoint, you would never apply for one until you got the other. And so it even goes beyond how long it takes to build, because the building on a larger project is usually, you'll do some speculation, maybe 100 units out of 200, maybe 200 units out of 400. You don't typically go above 200 units at one time, even if you have 6 or 7 or 800 units. So you build your 200 units, which is what the bank will finance, provided you got permits for 10 to 14 years. And then your building of your units will track your leasing activity, right? So no bank is going to say, go build 600 units and we're not even going to check the leasing. We just go ahead and build them all. And they're going to say, well, 600 is fine. You go build 200. You show us that the leasing is good. And then when you can prove that you've got a track record and a trend of your leasing, then we will fund according to that absorption rate, right? So the bank wants to see no more than a couple of buildings, which might represent 25 to 50 units, in inventory at one time, right? So you start out speculative, the market will then tell you the pace at which you will be leasing, which ultimately dictates the pace at which you would be building, okay? And so what I just said is what C.B. Richard Ellis put in a letter, and C.B. Richard Ellis, the 600-pound gorilla in the commercial real estate market. This individual is 42 years experience. They sold $156 billion of property last year. They are, I think, the largest in the country, maybe the world, but definitely the country, I think. And they basically said, as a result of the above history, now they did an analysis, this individual did an analysis of the absorption rate of New London County. And so then they applied it to our project, and they believe that the 864 units would take about 10 to 15 years build out. So then you get into the thing I alluded to earlier, which is statutorily, you cannot file certain applications parallel. You have to wait until one is approved before you can file the other. Now, as I said, from a practical standpoint, you shouldn't be filing for your OSA permit until you get your site plan for the reasons I've said, from a practical standpoint. But here is actually, from a regulatory standpoint, application must be made to the Office of the State Traffic Administration and a certification issued prior to the application to the district maintenance manager. And that's an encroachment permit for your DOT improvements. So you cannot file for your encroachment permit until you've already received your OSA permit. All right, so that it's not a parallel filing, it's a serial filing, and that's something that I don't believe that Ben took in consideration when he said, well, you can file all your permits. It doesn't matter when you get them, you just have to file them all. And you simply can't. From a practical standpoint and from a legal standpoint, you cannot file all your permits at the same time. And on top of that, that's not even counting Army Corps of Engineers. So your regulations, and you're a shoreline community, so if the Army Corps of Engineers get involved, you're looking at years before you can file your applications. And so there's no practical or legal way to meet your 12-month deadline. Absolutely, it is designed. An applicant will fail. Any developer who knows anything about developing will look at the regulations and simply say, it can't be done, and we're not interested, and therefore you don't get affordable housing, because they look at your regulations from the sewer and they realize it's a setup to fail. And so beyond the theory of practical timelines and legal timelines, we also have two examples of applications that came before you. And here's an application, and here's their timeline. They did not make the 12-month deadline, nor did they make the 48-month deadline. There's a little bit back and forth regarding the owner of the property. So here's 29 or 30 pages of backup information. When they filed, minutes of when they got their approval, when they started construction, and their completion, which the project has not been completed. So again, you have a example, and all of this is just all the backup information regarding when they filed their permit, when they received their allocation from the sewer, and the timeline is there. I'm not going to belabor it. It is what it is. It's all backed up by applications, minutes, and so I'll just move on. So all of that I just scrolled through is all the backup information to document the timeline that shows that from a practical standpoint you have an actual application that did not make the 12-month or the 40-month deadline. In addition to that, you have another application that came before this board that also missed the deadline, and that was Pizzaglia, I think it's called. No, it's I'm not sure. Let me see if I'll find it here. Pelletier. And so Pelletier came in and they asked for an extension, and an attorney, not his attorney, a different attorney came in and spoke to the commission and said, you are legally bound to not give an extension. You cannot give an extension of the 12 months. And then the city attorney, the marker, got up and said, he's right. The attorney's right. You have no discretion. You cannot give an extension of the 12 months. And these are the minutes showing that in fact, the 75,000 gallon allocation was terminated by this commission due to the failure to get all of their permits file for all their permits within a 12-month period. And again, every statement that I'm making here tonight is backed up by court documents, your own commission meetings, your staff department's reports. And so Exhibit 2.2-8 basically demonstrates that, and the point that we brought out in my letter last time, and I'm going to bring out again tonight, is that we are exempt from these regulations. We have a pending application in the court that was dated in 2007. It's called Application 6. It included Phase 2 of our property. And so therefore, until that is fully adjudicated, these regulations do not apply to us. And this is the legal notice that was issued. It says the application landmark for the approval of a preliminary site plan for the construction of between 1,548 and 1,720 units under the newly proposed Section 32 of the zoning regulations. And so that application included both phases 1 and 2. Now, we got phase 1 approved through the courts, and we got our 118,000 gallons for roughly half the project. This represents the second half of the project, but this is not our first application for phase 2. This is actually our second application. Our first application is still pending with the courts. And so we have an application that has gotten in well before these regulations were ever even contemplated. So these regulations cannot retroactively apply to application 6. So the commission moratorium and regulations and the wringing of the hands on capacity really doesn't match what their actions have been. And here is one of the commission members saying, Mr. Bond, on the end there, said he repeatedly heard discussions about future needs, but little progress has been made. He argued the commission has missed opportunities to expand the ratepayers' base and improve the town by extending sewer lines instead burdening current taxpayers for a capacity that remains unused. He highlighted the 100,000 gallons of available capacity just sitting there, not being utilized. And so clearly, the commission has sewer. They're trying to utilize it. They want customers. There are no customers, really. You're using 2,000-3,000 gallons a year you're giving out for the average over your trend, eliminating any spikes. And you're actually gaining capacity. You're getting more in efficiency than you're giving out in capacity. In addition, availability capacity was 189,000, another person speaking, but for the 4-month average of 2025, it's 338,000 gallons of capacity. Exhibit 2-10 is more discussions by the Sewer Commission. Mr. Bond said that he believes that the sewer capacity should be maxed out. He said that we should allow for more development and increase the ratepayer number. Mr. Zoller noted that the capacity situation is not as dire as it sounds. The capacity already allocated is being used at its fullest. Therefore, the sewer system is not going to overflow the New London sewer treatment plant. Exhibit 2-11 is former Chairman Nickerson basically saying that they don't want the courts interfering with the decisions that this commission makes, and that the judges can't force us to put sewers in there. Again, this relates back to my prior presentation where the town had hatched the strategy of using weaponizing the sewers to attack affordable housing. And the way that your regulations are written, everybody's exempt in town, except for applicants who have 20 or more units or require 5,000 gallons or more. So those are developers of multifamily. That's what you've exempted everybody but multifamily development. And, as it happens, multifamily development that's not affordable housing in the town of East Lyme is not allowed. There is no zone for multifamily in East Lyme. I talked to Bill Mulholland just to confirm there are no zones for multifamily. You'd have to get a zone change, and then even once you got the zone change, you have to get a special exception. So that gives the zoning commission absolute discretion to say, no, we're not going to give you this density. So when you eliminate multifamily market because the town doesn't allow it, other than special exception, which gives the town absolute discretion, which there's only one category of development that's left, affordable housing, because it's exempt from your local zoning regulations. So you crafted a regulation, and then you crafted that was meant to fail, and then you crafted a moratorium that exempted everybody in town except for multifamily affordable housing. And that goes right back to your original strategy that was hatched in 1999, as demonstrated by the notes from your lawyer advising the town how to defeat affordable housing. It all goes back to that original strategy. It's black and white, and you can connect the dots. And in Exhibit 2-12, Attorney I lost it there for a minute. Attorney Zamarka directed the commission to the attached document, and the town noted the town's usage chart and attempts to increase their limited sewer capacity. He recognized that it is a significant move, he's talking about the moratorium, but one that will offer a respite to prevent the town from facing lawsuits for rejecting applications. The moratorium was not based on capacity. It was not based on this made-up crisis. You guys are gaining capacity. You're trying to max out capacity. You're sitting on 100,000 gallons you don't know what to do with. It wasn't based on that. The moratorium was here to offer a respite to prevent the town from facing lawsuits for rejecting applications. And then he goes on to say, Mr. Zoller responded that they seem to have no alternative but to consider the proposal, especially since they had recently declined 8,000-gallon request. So that's the conclusion of my presentation. Clearly, what I have demonstrated through these exhibits totaled 117 pages, okay? Through minutes and documented meetings and court proceedings, that this town has more than enough capacity to give out 95,000 gallons to us. In fact, you gave out 75,000 gallons recently, within the last couple of years. You were very comfortable giving out 75,000 gallons. That's 75,000 gallons you got back. And so our 95,000 gallon request is only 20,000 gallons more than you were very comfortable giving away just a short time ago. And when you did give out the 75,000 gallons, you didn't have as much reserve as you have today. So it should be very easy for this commission to approve our request for 95,000 gallons, since it's only 20,000 gallons more than you were very comfortable giving out just a short period of time ago. Thank you.
Thank you, Mr. Russo.
Yeah.
Good evening, Mr. Chairman, Commissioners. I'm Attorney Tim Hollister, representing Landmark, the applicant. I have two tasks tonight. One is to give you two submissions and then to summarize what we believe are the overall justifications for granting this application. I just gave your clerk a binder, which I did not copy. It doesn't seem like it was a worthwhile use of paper, but it is a copy of the responses that we received, that either Landmark received or my office, to the August and September Freedom of Information Act requests that's covered both the sewer moratorium and the discussion of the affordable housing moratorium. And they were received in batches from Mr. North and Attorney Bleasdale's office, Attorney Collins' office, and the town clerk, the last batch of which was received Thursday. And again, it's quite voluminous, so I submitted one copy for the record, which your clerk has. The second is a court case that those of you with long memories will recall me talking about before, but in the events of the last several weeks has become quite relevant again. And it's a decision from 2015 of the New Jersey Supreme Court called 388 Route 22 Reddington Realty Holdings versus Township of Reddington. And I'll come back to what it means in a moment, but basically it's about the illegality of a town refusing to take back hundreds of thousands of gallons of sewer capacity that have been contracted out but not being used. Now, what I'd like to do is summarize the reasons, some of which Mr. Russo alluded to, some just give you a different take on why this commission should grant this application. First, please note, as Mr. Russo noted, that in an effort to compromise, the request has been reduced now to 95,000 gallons per day, about a 20% reduction. I think you've heard this from me before, but the commission's only job is to determine available capacity and what it can give a grant to Landmark without adversely impacting the physical management of the sewer system. Your job is not to use the sewers to manage collateral aspects such as land use and zoning. And I think it's also clear that we are proceeding in this matter under General Statutes 7246A sub B, not the 2019 regulation, which we have argued again and again is both illegal and impossible to deal with. Now, it's also important to bear in mind that this particular application was made at this time in direct response to our being alerted that the town was considering a sewer moratorium. We had to get this application in to make sure that we were grandfathered. Attorney Bleasdale's office confirmed that we have that status, but this was not our application. We were minding our own business, trying to secure additional sewer in other ways, but the town, the Board of Selectmen forced our hand. I think Mr. Russo made a very compelling case that there is ample capacity to grant 95,000 gallons to Landmark. You have his statistical analysis, which is, as he said several times, using the town's own numbers. The town is using less now than it did in the 2007 to 2020 era, even as more development has come online, such as the Gateway Apartments. There was mention of the Pelletier 75,000, which has now been rescinded or clawed back. We've talked about the 137,000 that your sewer administrator has identified as reserved to ticket holders, but of course it's clear that the ultimate use of that capacity, there is no time frame, no reasonable way to project, and indeed the capacity has been sitting there for a long time, and there's no reason to believe that it's going to disappear in the short term. Now, turning to the New Jersey case that I just gave you a copy of, it is simply incorrect, especially at this point in time, to say that there is 468,000 gallons that is off limits to the town of East Lyme and to this commission. Please remember, it is part of the town's contract with the New London Treatment Plant, the so-called Tri-Town Agreement. Approximately 250,000 gallons has not been used for at least a decade. There is no plan for use of that capacity, and the town, at least if you look at the general sewer principles that are discussed in the New Jersey case, is obligated to make a serious effort to recapture that capacity. Another way to look at that is who is going to object because the capacity is not being used right now. So the town and all landowners and taxpayers have a right to have access to that capacity, to come before this commission and say, I have a worthy project that will not impact the sewer system, and you should use that capacity. Think about it this way. All of the discussions you're having about how much capacity do we have to sort of this and that, you referred to turning down an 8,000 gallon application. If you claw back that capacity, all those problems go away. So it's time now for the town of East Lyme to step up and make a serious effort to recover that capacity rather than just sequestering it and saying it's beyond our authority. Mr. Russo mentioned at several meetings this year, several members of this commission have discussed available capacity in terms of 100,000 or more, 300,000 or more, and so the commission simply cannot just say we don't have capacity for Landmark without contradicting the Board of Selectmen, who adopted the moratorium to give the town time to figure out what its capacity is. I think they know, the town knows what it is, but you can't throw your hands up in the air and say we don't know. So in closing, I will sort of challenge you politely, professionally, and say if you're going to address this application seriously, you have to answer two questions. How much capacity is available to the town? And if we deny this, why is it not available to Landmark at this time, given the circumstances that we have outlined? And with that, I have thank you for your time, and I have nothing further to add. Thank you.
Thank you, Attorney Hollis. All right. Is there anyone else who would like to address the sewer commission? Ben? Again, if you would identify yourself for the record.
Ben North, East Lyme Water and Sewer. I think most of the things that I wanted to cover have already been covered in the previous public hearing, but I did want to try to speak a little bit to some of the things that I heard tonight and try to correct the record as best I can, because I do think there were some inaccuracies, and maybe they were, not intentional, but I just heard, I think, from Attorney Hollister saying that we have about 250,000 gallons of capacity remaining, and that's definitely the case, and our numbers show that. But what I think both Mr. Russo and Attorney Hollister completely negated was the fact that of that 250, 120 or 118, 400 is already reserved for Landmark, already reserved for their development. About 23,000 is already in projects that are already under construction. And we do have about 137,000 left over for ticket holders that have either paid their assessment or have been assessed that are sitting in the sewer system that the commission has always treated as priority over other development. And for parcels that are also in the system that in the past had been equated some capacity so that it could be reserved for future usage. So I think we all start from the same point. The numbers obviously don't lie. The developers have used the same numbers that the town has given, and I don't see any issue with that. But the issue obviously is that the town is trying to manage the sewer system in the current capacity that it has and the projections that it's seeing in terms of development that's already been started, development that's been planned and been approved, and development that's been court ordered by the courts that the Water and Sewer Commission is saddled with. Obviously, we would love to see any of these things move forward, and then we could better ascertain what our available capacity is, but without that happening, we really don't know for sure what we have left. So I do think that a better analysis is needed, and I think that that's something that we'll be talking about further very shortly. I've asked and it's actually an agenda item on our docket tonight for the Water and Sewer Capacity Subcommittee to meet and to discuss some of these things and how we move forward. And it's going to be my opinion that based on the perceived bias that the Water and Sewer Commission has, that I think we should take all of the data that we have and give it to an engineering company and let them tell us exactly what we have remaining, what we should be allocating for certain purposes, what we should be keeping in reserve for years that we have extremely wet weather that skews our results, as well as years that we have unforeseen circumstances that we need to deal with. I think we need to be careful that we don't over allocate, and that's exactly what I'm here to try to stress to the commission, is that we have a lot of obligations. We don't have control of our own destiny per se. We don't have our own treatment plant. We can't decide in 5 years we want to get funding and just increase that treatment plant. We have 2 other towns that we need to work with to make sure that that happens. So I think East Lyme is in a unique position in that regard, because we do have to work a lot of these issues out and a lot of these obstacles before we can really say, yeah, we have enough capacity to give out. The other thing that I wanted to mention that I did see in Mr. Russo's analysis, which he is obviously using our data, and he's seeing that the last 6 months have been a little bit lower than the previous years. I did some quick math myself as I was looking at the presentation, and I do agree that there have been 50,000 gallon fluctuations between the years of 2024, 2023, and 2022. And this is something that we report monthly on. We don't expect the number to be exactly the same every month, but we do expect that number to fluctuate, especially based not only on precipitation, but on groundwater levels. We do see that there's some correlation between that, and while we're not exactly sure how we can predict that, we do know that this past year, on a typical year, we would see about 61 inches of precipitation. This year so far, we've only received 33 inches. We should be on track to have about 45 inches of precipitation, so we're about 12 inches lower than we normally would be. We're about 27% off what our typical average is. So I do think that plays a factor. I don't exactly know how to quantify that, and I think that's something that we should look at with our subcapacity analysis and with our engineering firm. I think we could probably use data, and I say we as in our engineering firm could use data to better give us an analysis of what kind of reserve we should be keeping for something like that. I also think the Water and Sewer Commission has actually done a pretty good job in keeping the allocation moving forward in a way that we are working with our partners in trying to see what we have available. We've sent letters to the state of Connecticut. We're actually waiting to hear back from the DOC now on whatever capacity they may have in reserve that we might be able to use. We worked with Waterford and New London, who both are on board, to upgrade the Thomas P. Ascenti facility and be able to get more capacity through that means. So I don't think we could say that we're just sitting here as a commission trying to stop growth and trying to stop development. I think this past few years especially, we've worked hard, and I think that's evidenced in the commission's deliberations that we want to allow the town to grow if it wants to do that. That's not something that we're trying to hold up, and I think Mr. Russo identified some of those internal struggles that we've had, because we do want to be a steward for the town and to make sure that we're supporting the town, but we need to do that responsibly. So finally, I just want to add a few things to the record. I'm going to add some more sewer data from January 2025 that gives us a whole year outlook of 2024 and the precipitation. That's going to be Exhibit 19. Exhibit 20 is going to be a backup for that. Exhibit 21 is going to be January 2024 outlook on, or I should say a recap on the 2023 year and the backup for that. And then finally, the most recent data that we have to add to the public record, which not only shows what our flows have been, but what our precipitation has been over that amount. which I do think is a factor that we need to discuss further and really better understand. So at this point, those are the pieces of information I wanted to include into the record and speak to the commission on. I think it's a positive note that Mr. Russo wants to reduce the capacity allocation request from 123,000 to 95,000. I am a little bit concerned that I have no backup information for what that is, so I don't know how many units that corresponds to. I don't know what type of formulas were used in that calculation. I was familiar with what had been included in the first public hearing packet and application, but I haven't received anything for this request for 95,000, so I really don't know how to make any kind of recommendation for what that actually means and whether or not that's actually a feasible calculation. But at this point, I have all the information that I wanted to discuss with you, and I think I'd just ask Tracy Collins briefly to discuss some of the regulation side of this, which I think was spoken about a little bit, and I want to stay in my lane as the engineer telling you what our capacity allocations are, and I ask Ms. Collins to just talk a little bit more about our regulation and how it might fit into this whole thing. Thank you.
Good evening. My name is Tracy Collins. I'm the town attorney. Before I answer Ben's questions or address what he asked me to address, I want to caution you that although Ben brought up the moratorium tonight, you should not take the fact that the Board of Selectmen has adopted an ordinance and a moratorium on sewer capacity because Mr. Russo got his application in before the moratorium was enacted. The law is clear on that. He is entitled to a decision tonight based on the merits of his application, and the fact that the town has a moratorium should not enter into your deliberations at all. As far as the regulations, so the town has enacted the regulations. We know that Mr. Russo has appealed those to a higher court. And so today, as you sit here, these are our regulations, and the only issue before you tonight, or whether or not you, in your determination, in accordance with the current regulations, the town has enough capacity to give Mr. Russo what he asked for. Does that answer your concern, Mr. North?
Thank you.
Okay. Does the commission have any questions in that regard? Thank you.
I have a question.
We do have a question.
Not specific to what you just said,
Mm-hmm.
but in listening to the prior testimony, I'm understanding now that there's a question about the 137,000 that we are considering as an obligation because of the ticket holders. And then reference was made to there was a prior approval of 75,000 for, and my recollection at that time, and I think it's reflected in the minutes when that was, that there was contemplation that we could purchase some additional capacity from either Waterford or New London or maybe both. And so at that time, the commission, in making that approval, dipped into the 137,000 reserve.
Mm-hmm.
And subsequent to that whole situation, and maybe this is a combination of a question for you and a question for Ben,
Mm-hmm.
but our understanding is that it was not going to be possible to purchase additional capacity from Waterford or New London, that neither community was interested in selling capacity at the time. So that altered that. And now I'm understanding from an attorney for the
Mr.
applicant,
Hollister.
right, that because of this New Jersey court case,
Mm-hmm.
that the 137,000 that we should be perhaps, because of the longevity, be treating it differently. And so in terms of legally, because we've always understood that there was an obligation, because if people had paid an assessment or were already assessed, that we had a legal obligation to commit certain, reserve certain capacity. And knowing that, I think you understand my question, so.
I do.
Yes.
And if I may, with all due respect to Attorney Hollister, I have not read the New Jersey case. And I would say a New Jersey case is not the law of the state of Connecticut. And the law of the state of Connecticut is what applies in these applications and appeals. So without having read that case, I cannot give you an opinion whether you should consider that New Jersey case, other than to say a New Jersey case only governs New Jersey law. And while it may be an important case in terms of sewer capacity in the United States, it is not the law of the state of Connecticut. And as far as the technical question that you asked, I think that should be answered by Mr. North.
And just to follow up before Ben speaks, so there's not a change in guidance in terms of how we need to hold our obligation to the ticket holders, the 100, is there any, there's not change in the legal guidance to us?
There is no change in the legal guidance to you based on that New Jersey case. I haven't read the case, but because it's not a Connecticut case, I would say that it would be reasonable for you not to be guided by that.
Thank you.
Thank you.
I was going to touch on a little bit of the letters that we had sent to Waterford, New London at the time, looking for 100,000 gallons of capacity, up to 300 each from Waterford and New London that we requested during the Trachis hearings and applications. I should say Pelletier, part one. And yes, at the time we did send those letters out to both Waterford and New London, and we thought that, especially because there was a flow dispute between Waterford and New London, that Waterford felt it was using much less flow than it had previously used in the past. We thought that maybe that was an opening for us to be able to get more capacity. So I think we were optimistic at that time that was something that we might be able to do, but in the interim of granting the capacity, we found later that that wasn't going to be the case, and that those commissions were not going to be able to sell us capacity or even allow us to borrow it. But I do think ultimately it started the conversations that are to where we are now, where all three towns do agree that we need to upgrade the facility, and we're all looking at that very seriously. And I understand from talking to my counterpart in New London that an RFP is in the process right now, and that hopefully by the end of the year we'll have something in place to start that process.
Thank you, Ben. Anything further? Any rebuttal? Yes. Attorney Hollister?
Thank you. Tim Hollister for the record first. Mr. North misunderstood what I was saying about the New Jersey case, and I would say to my colleague, Attorney Collins, that the reason she's not familiar with it is, I think, because she's new to this case. But Attorney Zamarka was aware of it because I've been raising this case since 2016 in this particular matter. So it's nothing new. But the applicability of the New Jersey case is to the portion of your 468,000 contracted gallons to the state of Connecticut that has not been used, not the 1,022,000. So the point is, there, especially with the reduction of sewer use because of the closing of the prison, there is approximately 250,000 gallons out of the 468 that has not been used, and that is what you need to claw back. And that is what the New Jersey case says. And it is a New Jersey case. It would be nice if we had one in Connecticut, but New Jersey talks about equity and fairness in sewer law. And the outcome of that case was that where there was something like 362,000 gallons that were just sitting there, controlled by private entities and not being used, there was an implication that it was being used to fend off economic competition. The case doesn't resolve that issue. But the point is, it was there, and the people of the township said, we have a right to use that unused capacity, and the Supreme Court of New Jersey agreed with them. So it's what lawyers call persuasive precedent, not binding precedent. Thank you.
Mr. Hollister,
Yes, sir.
was the 362,000 owned by private?
No, it was the town's allocation, it was the town's capacity.
It wasn't the state, though.
It was not the state. It had been contracted to private
Well, in that
parties.
case, it's the state that has the capacity.
Yes,
We
I'm so.
don't have control over that.
Yes, you do. You have the ability to go to the state and say, this capacity has been sitting there for decades, not used. We would like some of it back. That, in my understanding, a serious effort has not been made by this town to go to the DEP, to go to the state and try to retrieve that capacity. This case from New Jersey says you have an obligation to do so because it is part of what you have contracted at the New London treatment plant, but it's sitting there unused. So I don't think it makes any difference. In the New Jersey case, it was contracted to private parties. In this case, it's contracted to the state of Connecticut. That's not the point. The point is it's unused. And I should also mention, Mr. North talked about the 137,000. The 137,000 could only be preserved if you, the commission or the town, had a predictable, verifiable timetable during which that capacity will be used. My understanding is it is also a number that's just been sitting there. I've been involved in this case since 2011. It was never brought up from 2011 to 2018 in the prior application. Then after Mr. Russo prevailed, all of a sudden it became a relevant statistic, another way to sort of keep Mr. Russo and his application at bay by saying, oh, this is reserved. But it wasn't reserved always. It was reserved after we prevailed in the court case. So let's not recharacterize it. It is what it is, and there's no timetable that I have heard or seen as to when that capacity is going to be used. The track record is it may never be used because people don't want to hook up. Thank you.
Mr. Russo?
Yes, thank you. Ben is
Just so it's on the tape, just identify.
Glenn Russo.
Yeah, thank you.
Ben is not accurate in what he said earlier, and I think that when I was going through the presentation, I had a lot of material to cover, so I was going very quickly, and so I don't think it's Ben's fault. I'm not sure he's read the line that we had, but when we did our analysis, we assumed the town had 119,000 gallons of available capacity, not 300 or 200 or any other number. Our number that we used was 119, which we got from the town from a prior calculation of sewer capacity, but falls in line with the general understanding that I believe that everybody believes that it's, tonight I hear 137. We have minutes that say it was 119. So we used 119 as our number, as our analysis. And we subtracted from that our request, and based on, so the first thing, it's 119, the number that we used, which I think the town would admit they have. Okay, that's number one. Number two, Ben talked about the last 6 months and fluctuations in rainwater and how that could skew. That's why we did 4 different time frames: 2.5 years, 4.5 years, 6.5 years, and 14.5 years. Okay. On the 14.5 year and the 6.5 year, the town, based on having 119,000 gallons, based on their past usage over a 6.5 year period, and a 14.5 year period, the town would have somewhere between 7 and 10 years of capacity left for future people who wanted to hook in. If you were to take the 4.5 year trend, which people would argue is the most accurate trend, the town actually is gaining capacity. They're actually having less capacity over the last 4.5 years than they gave out. Now that's just the town's own numbers, okay? And in the 2.5 year trend, it also shows that the town got more capacity. Now, the town has argued, and we have minutes to this effect, that the town should not be using the 5-year trend any longer, and I don't remember which commissioner had brought it, but the more accurate in the commission's view was to use the 2-year, the shorter time frame. And those comments are in our package as well. So, as it relates to this anomaly, or the claimed anomaly, that's why we did 14.5 years. That eliminates, oh, it rained, it's going to rain some more, it's going to rain a little less. That's all factored in the 14.5 year, 6.5 year, and the 4.5 year. And an argument could be made that over 2.5 years, it would even out. But we're saying that if you take the 6.5 year, which certainly the highs and lows for additional rain are evened out, and the 14.5 year, the town still would have, based on their past trends, they still have between 7 and 10 years of capacity to give out to the same amount of people that have come in over the last time period, whether it was 2.5 years, 4.5 years, 6.5 years, or 14.5 years. The reality is that there isn't a lot of demand outside of multifamily for sewer capacity. It's just not. It was 2,000 gallons a year on average over a 14-year period, 3,000 gallons a year on average over a 6.5-year period. Those are small numbers compared to what the capacity that the town admits it has today, which is at least 119,000 gallons, maybe as much as 137,000 gallons. We didn't use 137, we used 119. Thank you.
I got one question for you. Let's say this commission approves this 90,000 gallon on top of your 113 you got already?
118.
118? When are you gonna build something up there? What's the time frame? What is the time frame for you to actually build something and start putting sewer in this system? That's my question. We've been kicking this can down the road, and you want 200,000 gallons of capacity that we really don't have, do have, and then when are you gonna start putting sewer in the system?
Well,
Right now, with your prediction, you got a lot of numbers, and what are your predictions?
I would say two things. Number one is when you say we do have it or we don't have it, remember the town claimed for 6 years they didn't have the 118,000, which we now have.
Listen, let's not even hash that out. Bottom line is, if we give you the 90,000 gallons and you have your 200,000 gallons, when are you gonna start putting sewer in the sewer system?
Well, it really would depend on when the town stopped passing regulations
This has
that,
nothing to do with us. I'm just saying, sewer, when do you?
no, when the sewer commission stops passing regulations on the way the sewer can be used, then we are presently in court on 2 separate cases, correct? On 2 separate cases.
We need to get rid of the deadlines too, not just.
Correct. So every time for example, to answer your question, the day that we got our the day that the court forced with a potential contempt citation against the commission, that very day you gave me the 118, and then you passed the regulations on the 12-month and the 48-month and all the rest of that. And that wasn't until many years later, through the appeal of that the town finally admitted that those regulations were grandfathered in from those regulations. So a lot of the delay has been due to the conduct of this commission after we received our 118,000 gallons with new regulations and new requirements, which were unclear. And my attorney wrote letter after letter to the town saying, do these apply to us or do they not apply to what we already granted? And we could not get a straight answer until well into the appeal period, if I'm correct. Is that correct? And we could not get a straight answer out of the town until well into the appeal period because the court forced the town through briefing to take a position that it either did apply to us or didn't apply to us. So the town has continually, even after they gave us the allocation, continued to write new sets of regulations, and we're being vague as to whether or not they actually apply to our project or not.
Okay, well, we have a town attorney. What are the parameters? When we get down to brass tacks here, as a commission member, you know, here, we all sit here, we jump through these hoops. He has 118,000 gallons already allocated to him. He wants another 90, and it's very frustrating that the 118 now is holding up other development. We have, like you said, we have the state. We've been dealing with that, but now here we are. If we gave him the 90,000 gallons, he's got 200,000 gallons of capacity. Is there a true roadblock that's causing him not to develop? Or are we going to be sitting on this now 200,000 gallons? We can't let anybody have sewer capacity until we get more capacity down in London, which is going to be years down the road. So
I'm not sure that's a legal question, but I can tell you that the most recent regulations that the commission adopted were appealed to the state of Connecticut Superior Court. The town won that appeal, and now Mr. Russo is appealing that to the appellate court of the state of Connecticut. So beyond your question, Mr. Russo is entitled to the 118,000 gallons that he has. And if your question is, if we give him another 90 or anything, when would he have to start building? As we stand here today, the newer regulations apply. But he has appealed those first to the Superior Court. The town won at the Superior Court, and now he is appealing that decision to the appellate court. So that's anyone's guess.
okay, that doesn't help.
No, I'm sorry. Mrs. Russell?
A question, since it was brought up about our agreements with the state of Connecticut in terms of capacity that the state of Connecticut has for the prisons and Rocky Neck and the National Guard.
Mm-hmm.
You know, the was it 478,000, I think. And my understanding, and I'm on the subcommittee, the sewer capacity subcommittee, so I started actually, because of that, looking at those agreements.
Mm-hmm.
And my understanding is that they're, from the language in there, and I'm not an attorney,
Mm-hmm.
but that we cannot unilaterally, in other words, any changes to those contracts, it has to be negotiated between the parties. You know, the state of Connecticut can't unilaterally change something, nor can we unilaterally change something. That's, and I don't know if you are familiar with those agreements, but that's...
You are correct on that point, Ms. Russell. The town cannot unilaterally give away capacity that the state has a contractual right to.
I believe those contracts, when we were starting to build the sewer system, was tied to money that the state gave us to help us build start the sewer system.
Yeah, that's what I've read.
Yeah, that's true.
So they basically bought that capacity from the sewer system for us to help us build the initial phases of the sewer system.
It's my understanding, although you don't see me a lot, I have been at Waller, Smith and Palmer for 39 years and have been listening to all of this and through various first selectments over these so many years, that very often the town has asked the state for capacity and the state has said no. Ben, can you address that?
Yeah,
Or-
we've done that, and recently we asked the DOC, and the DOC is the largest holder of capacity with the state at this point, and we've made a request recently, and we're waiting to hear back the response on what that request is. Matter of fact, last week I asked for an update, and I'm still waiting to hear back, but I'm told that a letter is being drafted.
And another point of clarity relevant to the state agreements, in terms of the capacity that was given to Point of Woods and the capacity that enabled sewers to go into Pine Grove, that as such time as we get additional capacity at the treatment plant,
Yeah.
that we would, East Lyme would have to then absorb, in other words, it's right now there's a certain amount of capacity reserved for Point of Woods and a certain amount for Pine Grove, and the state is absorbing that out of what had been their Rocky Neck allocation. And once we get additional capacity at the treatment center, the state should be made whole, if you will, for its 400, for Rocky Neck, and we would absorb Point of Woods and Pine Grove on our side. So the state has been very concerned about keeping their 478, and that they made it very clear that Pine Grove and Point of Woods are just alone. And that's, again, I was looking at those agreements because of being on the capacity subcommittee, because that's things that I wanted to look at.
I can say from being around many tables all these years that the state does not seem inclined, and even though repeatedly asked, to give us any of their capacity. Does that answer your question, Ms. Russell?
Yeah, and I was just pointing out about once we do get additional capacity, if that, through the improvements, and that's a long-term process, but we'll have to repay the loans, if you will.
Right.
Yeah.
Thank you, Tracy. Is there anyone else who would like to address the commission on this matter before we'll be closing this hearing, correct?
I have one other question for Mr. Russo. Your figure of 119,000 are you taking into account that we, for example, the 118? In other words, is the 100? You're saying 119, but then we would have to say, oh, but out of that we've already committed the 118, and we've
No.
already,
No.
Can you explain?
Yeah,
Yeah.
very briefly. So you take the town's total capacity that they have available. Ben can correct me if I'm wrong, but I'm following basically the way that he has determined it. We follow that same method. So you take the total available capacity, then you subtract from them that the legal obligation of the 118, that brings it down, and then you deduct from that other capacity which has been already granted, and projects have not been built, or projects that are under construction. So you can't take away capacity that you've given to somebody, and you can't take away capacity for projects that are under construction. So you take the total amount available to the town, subtract what the town is now legally obligated to give out to me, what they've given out to somebody else who has not started, or to projects that have been started but they haven't tapped in yet. If you subtract those, what you're left with is 119,000 gallons from past analysis that we found. Now, as of tonight, I'm being told maybe it's 137,000, but we used 119 because that's what was used in a recent capacity allocation computation that the town did. I think I got that right, Ben, right?
Yeah, it's pretty close. I mean, we do the same kind of analysis, and if we don't earmark anything for ticket holders, we don't earmark anything under Part C in that capacity analysis, which is where the 137 comes in, then we would have about that left over. So, again, we start with about 250, we take out 118, we take out 23, and then if we were to just subtract all those things, we end up around that number. But the big difference is, we're trying to allocate, again, for not only for projects that are under development, but also ticket holders that have either paid their assessments or been assessed. And so that's the big difference here. We're trying to make sure that we're holding enough capacity for those ticket holders, and whether they've developed the land yet or whether they haven't. And hopefully, I would think that's the fairest way to do this, is to try to make sure that we've already, we've left reserve for the allocations that we've already doled out. We have caveats and they're filed on the land records that this is a benefit to the property. Our understanding is, and that we have a legal obligation to hold a capacity for those properties. And so that's the discrepancy.
So basically, you and Mr. Russo both agree as to the starting point is.
Yeah, I think,
in the 250.
we're probably a few thousand different, but yeah.
And the difference.
Yeah,
is-
right, it actually ends up being about 110, yeah.
and-
Well, right, exactly, so it's 110 if you were to go to zero, right? We're at negative 26 with the 137, so you take out the 26 from the 137, you get about 110.
So what exactly is your starting point, and what exactly is Mr. Russo's starting point before you start deducting?
I think we're starting at the same starting point,
So it's
right? About
We are
250.
starting at the same starting
Yeah.
point. We're ending 9,000 gallon difference.
So
Right.
the difference is how we treat the ticket holders, is that?
Yeah,
Is
exactly.
that what it comes down to? Is that?
That's my feeling, yeah.
Is
That was the argument that you made and lost in court on the 118. So it's the same, you've already made that argument once, and you've already lost once. And so now it's the same argument that you have this capacity that you're reserving for other people who might connect in the future. That was the exact argument that you made and lost in court when the court granted us 118,000 gallons. But to answer your question, I use 119,000 gallons. I think they're maybe about 110. So we are within 9,000 gallons of each other as to the amount of capacity that is available, that we are asking to have 95,000 gallons of that allocated to us. And as it relates to the ticket holders, okay, if you take the last 10 periods of time that I did for you, and you look at what these ticket holders have been asking for over a 13.5-year period of time, a 6.5-year period of time, a 5.5-year period of time, what these ticket holders have come in and asked for, okay, would still leave, if the trend stayed the same, and there's no reason to believe it would not stay the same, the town would have a minimum of 7 years and more like 10 years of capacity to these ticket holders, okay? And that's using the 13.5-year and I think I'm going, remember here, 6.5-year. If you use the 4.5-year, you are actually gaining more capacity than your ticket holders are coming in for asking for capacity. You're actually gaining. You gain 50,000 gallons over a 4.5-year period of time. Through the methods of, through the possibilities that I've laid out. Water conservation appliances, better metering, less people pumping stormwater into the sewer system. So those three, and there could be more, okay, are gaining you more capacity, then your ticket holders are coming in asking for capacity. Does that explain?
I'm processing. I don't know if this triggers any.
Ben, I
Questions?
think I explained that correctly, didn't I?
Yeah, I think the main, the
Ben, if you could use the microphone
Sure.
so Ron can.
Yeah, I think the only thing I'm not sure I agree on is that just because we haven't seen ticket holders clamoring to tie in to our system in a certain amount of time, and that the rate of our sewer capacity is somehow not keeping pace with the expected rate of our ticket holders tying in, I don't think that, past results can predict future outcomes, and so that's my caveat there. We don't know when the ticket holders are going to tie in, and that's what makes it hard for us to predict when we can understand that they will tie in. But we do understand that we have to reserve capacity for when they do tie in. It's their prerogative. It's on their land records. It's their right to tie in if they wished.
And then one of the things that we're assessing now is the 137 figure. Correct?
Yes, yeah, we're currently assessing that now, and we're updating the parcels that we have remaining in town that have tied in versus haven't tied in. And my proposal is going to use that data to work with an engineering firm to better allocate capacity in the future. And if we could try to make predictions as to when we assume that capacity could be used, we can present that. I mean, again, I think it's a little bit of a fallacy to say that, well, we've tied in ticket holders at a certain rate over a certain amount of time, therefore we should expect that that's going to continue. Maybe if we were to give ourselves quite a bit of a buffer on contingencies on that, because I think it could fluctuate quite a bit, especially something like, you could even throw out, median household age. We have certain age of systems that last a certain amount of time, and we could see an influx after a median period of time where a lot of septic systems are failing, and now people do need to tie in, and maybe we haven't hit that nexus point yet. So those are things that we need to concern ourselves with, that a developer asking for capacity from us certainly doesn't need to concern himself with. So obviously we need to be really responsible with how we're dealing with the minute capacity that we have left.
All right, is there any more evidence to be presented with the landmark presentation? So then at this point, we will close the hearing with respect to, I guess.
I would only say I don't have any information on this 95,000, so I don't know how many units that equates to anymore. Maybe that's maybe we have something on that.
I'm not sure why that's only for me, but, okay. So we gave a site plan that showed that we could fit the buildings on the plan that would require 124,000 gallons of sewer. Okay? And you saw that plan, and you agreed that plan met the requirements of your regulations. Correct?
Well, I'm up here talking on it. This is the SLR information, right? So I think what the question you're asking me is do I concur with the SLR analysis? I'm not sure that I do. I think that the SLR analysis was based on certain pricing of expected value of the rents in certain areas, and so an occupancy level was established based on the price point of the rental units over a 10-year period of time. That was about 10 years ago now. Well, I'm sorry, it was a 4-year period of time between 2012 and 2016. So I don't think the number is wildly inaccurate, but I do think that it doesn't follow the typical criteria that we use when we look at analysis. We've looked at the subsurface sewer the subsurface disposal guidelines from the Department of Health, which is where the 150 gallons per day per bedroom comes from. And then we've looked at our own data. We've looked at 3 developments over 3 years of time to get a really good average of what their usage is. And then we've added a 50% safety factor to that real world data. So this application doesn't have that. It has this extrapolation, again, based on a housing survey that was done by CCOG between 2012 and 2016. And in that data, which is included in the packet, it tries to ascertain occupancy based on price points of rental units. And so we really have no idea what the price points of these rental units are going to be, so it's kind of hard for us to back out of trying to understand what they might be. And I would also, I'm not a sociologist or a person that would understand the habits of people that post-COVID based on occupancy or the affordability crisis that's in the state of Connecticut, but I might wonder if the numbers still hold up from 2012 to 2016. So I would be much more comfortable in using data that was based on analyses that we've done before, which is based on our own data or the DPH findings. But so that's a little bit of the issue that I see with the SLR analysis. I think there could have been better ways to get that data with ways that we've already recommended. We've had success with a lot of other developments in using this methodology. So that's a little bit of what I'm a little bit uncomfortable with, I guess, is the word I would use. And then the reduction from 123 to 95, we're guessing that's about 25% reduction in capacity, so that must be commensurate with the number of units that are requested. That must be a reduction of the same. Is it linear? Or?
I'll answer them all at one time.
Okay, all right.
Sticking on the question, with Ben's concern. First of all, the analysis that we did for this application is identical to the application for the 118,000 gallons that we applied for before. That has been accepted by the town from a prior application. It's never been challenged in court. It's never been challenged here that the calculations that we did are somehow not valid. So it's the same calculations that we filed on the 118, which has been upheld by the court. So that's number one. Number two is the challenge to the method of determining the amount of sewer. I'm hearing it for the first time now. There's no, as far as I know, there's no memo, there's no phone call to me or any of my engineers saying we're questioning your calculations. The third thing is that we showed, and it was accepted, and our application was classified as complete, because Ben specifically said your application is considered complete. He asked for a couple of more pieces of information. I gave it to him. He said, fine, you're good, you're complete. Okay? And so we showed a number of buildings, and we showed that these buildings require 125,000 gallons. Okay, we are reducing to 95,000 gallons. There will be less buildings. If we could fit the necessary buildings for 125, we can certainly fit the necessary buildings for 95. It is a smaller project. So to have concern that 95, somehow 125 is okay, we looked at the site plan, the buildings are okay, they fall within the necessary area, but somehow if you make it smaller, that's going to be a problem. It doesn't make any sense. And the last thing is, really, this commission should not be asking about the number of units or floor plans or elevations, all the things that we gave, because you're not a zoning commission. You are a sewer commission. Okay? It doesn't matter how many units we're asking for. We're asking for capacity. And when you start to step in and say how many one bedrooms, well, we think that's too many one bedrooms, or maybe the buildings are too tall, or maybe it's too dense, that's not your area of expertise. Legally, you cannot make those type of judgment calls. You are a sewer commission. You either give a capacity amount or you don't. Now, with that being said, Ben asked for this information. We didn't think that he was entitled to it. We gave it anyways, still reserving our rights because we don't want to then have the town say, well, you waived your rights because you gave him the information. But just to keep going and to keep in a working relationship, he asked for this information, we gave it to him. But we showed that a development of 125,000 gallons works and fits, town accepted it. I don't see how they could possibly say that a development of 95 doesn't.
Yeah, I just correct the record. I'm not saying that that's a problem, but we have this letter from SLR giving us a breakdown of how the calculation was done. So I think that it's a little bit of a stretch to use this type of calculation. I think maybe Mr. Russo was originally using the 1.5 persons per day, not the 148, right?
That's my engineer.
Yeah, so that's all that I'm trying to make sure, and I would speak to the regulation that I think the intent is for us to make sure that this passes the smell test, right? You know, no pun intended. We're talking about sewer, but we want to make sure that that seems reasonable. That the 95 or the however many units are being proposed could be served by 95,000 gallons. That's why the commission wants to know this information. That's certainly why I want to know the information. I wouldn't want to, you know, I don't think this is a wildly off analysis. It is a little bit irregular. I've never seen an analysis done this way, but I think that what I really just wanted to get more information on was what the reduction in unit count was, and it sounds like from what we just heard that the unit count will drop commensurately with the capacity that's requested. So I think that answers my question.
Thank you. Yeah,
I just wanted to confirm that is correct. The unit count will drop proportionally to the sewer.
to the sewer capacity.
So I think that's kind of what you wanted to get at.
Yeah, exactly.
All right.
I think that's understood.
Excuse me, Dan, I have one more question for the town attorney.
Yep.
Mr. Russo stated that in the court ruling relevant to the 118 that was already granted, that the court made some ruling relevant to what our obligation to the ticket holders would be? Is that, I hadn't heard that specifically before.
That is not my understanding, but I haven't read that case in a long time, and I think that maybe when you're with the subcommittee that you should read it.
So from I guess I'm just reviewing our obligation to the ticket holders because that seems to be
Very important.
Yes.
It's my advice that you can take into account the ticket holders when making a determination whether there's capacity for Mr. Russo's project. Was that your question?
I'm guessing, well, I'm wondering about our legal obligation, or what is our, but
Your legal obligation is to consider that when you're determining capacity, who has the right to capacity? Just as, that's a decision of this commission, whether it wants to consider the fact that the ticket holders may need the capacity that you've promised them.
I guess what I'm saying is in the past, we've been advised that, that's the term, ticket holders.
Yes.
That they had rights
They-
to a certain amount of capacity.
That capacity has been allocated to them. So if they all come this week, next week, in 2 years and want their capacity, you will be obligated to give it to them.
Okay, is there any other evidence that wants to be presented tonight with respect to Landmark? All right, then, with respect to that portion of the public hearing, that will be closed.
I'll make a
We need
motion to close the meeting.
I'll second.
We have a second? Okay, any further discussion? All in favor signify by saying aye.
Aye.
Any opposed? Motion carries. So that presentation is now closed. Next on our agenda, item 3, presentation on the determination of capacity for Dan Tracus et al. Concerning a development 2002 Pennsylvania Avenue. We do have a letter. Did you want to read that in, or you want me to do it?
I can do it if you want me to. The letter is addressed to Dan Cunningham, Chairman, East Lyme Water and Sewer Commission, 108 Pennsylvania Avenue, Connecticut. Copy to Mr. Ben North, Chief Operating Officer, East Lyme Water and Sewer, 108 Pennsylvania Avenue, Connecticut. It's from Theodore Phillips and Mark E. Block, attorneys at law, and it's in regards to the sewer capacity for property of Daniel Tracus et al. Dear Mr. Cunningham and Mr. North, please be advised that the undersigned represents Mr. Maurice Gwendo, the proposed developer of property of Dan Tracus at 200 Pennsylvania Avenue. This matter is on a public hearing agenda for October 28th, 2025. Unfortunately, Mr. G will be prevented from appearing at the public hearing due to a personal matter. In addition, the applicant has been requested to submit additional information which is necessary to complete the application. The additional time is necessary to provide that information. Therefore, request is hereby made that the matter be continued to the November meeting of the Commission. This request is being submitted with the consent of the applicant, Mr. Daniel Tracus. Thank you for your consideration of this matter. Very truly yours, Mark E. Block.
Okay, so we have a request to continue it to our November meeting. Do we need a motion for that?
Yeah, we do.
We do.
I'll make a
Okay.
motion to continue it till next month's meeting.
I'll second that.
Okay. Any discussion? All right, all in favor, signify by saying aye.
Aye.
Any opposed? Being none, the motion carries, and that'll be continued to the, do we have the date for our November meeting?
It's a weird one.
It's a week.
So it'll be
11/18.
11/18.
Yes.
Okay, so it's on the record, 11/18. Great. All right, thank you. Yeah. Okay, so that is being continued. Is there any additional public comment tonight? Yes.
Yes.
We're still in the.
I also have some letters to submit to the commission.
Is this for Trickus?
What is this for?
My name is Roger Reynolds. I'm from Save the Sound. This is with respect to the application of Landmark LLC.
We closed the hearing. The hearing.
This was, the public comment was listed before adjournment on the agenda, and I didn't hear any call for public comment during the hearing.
Well, public comment is after on the agenda.
And then it says adjournment,
Right.
so
What's that? Yeah, this isn't specific to any particular presentation.
But it wouldn't be in the record.
The hearing is closed for Landmark.
Yeah, so
Tracy,
the
what-
public comment should not address Mr. Russo's application.
Okay, thank you.
So there was no public comment period for the hearing itself? There was no opportunity for the public to comment?
We had asked anyone that wanted to make comments, so you could have made comment.
Respectfully, you asked wasn't clear. You asked whether there was further evidence that you wanted to introduce into the record, not inviting public comment.
I guess respectfully, we had misunderstood in good faith because I looked at the agenda and it said landmark hearing, and then it said the trachis hearing, and then it said public comment, and then it said adjournment. So based on that, I believed that you were still taking public comment, even though the evidence by the parties was closed. I didn't hear a request for people other than actual parties to speak. And I know there are a number of other people, at least 3 others, who would also come here planning to give public comment with respect to that hearing. So I guess,
Can we reopen?
I'd ask for advice from council on that issue. Tracy, what would be the proper procedure?
You should not reopen the hearing. Mr. Attorney Hollister has already left. You cannot reopen the hearing.
Okay.
And there is no requirement, while it's unfortunate that there was this misunderstanding, there is no requirement for public comment.
Okay, so we're going to live by that. Thank you. All right, so having understood that, yeah, do we have a motion to adjourn? What?
Motion and second.
To adjourn?
No.
Adjourn the public hearing.
Right. The entire public hearing, not just,
Yeah.
yeah. Okay, so we do have a motion, all right. All in favor of adjournment signify by saying aye. Aye. Any opposed? All right, motion carries, so the public hearing is concluded.